Hello students, welcome to this lecture on the course Principles of Political Science. Today's lecture is on the relationship between political science and law. It is lecture 10, Interdisciplinary Approach, Political Science and Law. In our previous sessions, we have discussed the relationship between geography and political science, and now we are taking up political science and law. So you see that law and politics are intertwined at the very roots of organized human society. Every political system is simultaneously a legal system. Also, government exercises power through law and are constrained by law and draw their legitimacy from law. At the same time, law is made, interpreted, amended, and enforced through political processes and political institutions. Understanding one without the other produces an incomplete and distorted picture of how society is governed. Here is our agenda for today. We'll begin with the meaning and scope of law as an academic discipline. Then we will examine the two-way relationship between political science and law, and then we will discuss the key concepts, the rule of law, constitution, rights, and duties, and of course justice. We'll explore the Indian examples, including the Indian Constitution, fundamental rights, and judicial review. We'll compare the two disciplines and discuss the limitations as well as interdependence and the limitations of the interdependence also. Let us first define what law is as an academic discipline and as a social institution. Law is one of the oldest and most important human institutions. At its most basic level, law is a system of rules created and enforced by a governing authority, whether a state, a community, or an international body, to regulate human behavior, resolve disputes, protect rights, and maintain order within a society. The English word law has Germanic origins derived from the Old Norse word leg, meaning something laid down or fixed. This etymology reflects the essential characteristic of law. It is deliberately created and imposed on society by an authority with the power to enforce legal rules backed by coercive power of the state. Various thinkers have defined law differently. The British philosopher John Austin defined law as the command of a sovereign backed by a sanction. The natural law tradition, represented by thinkers like Thomas Aquinas and Grotius, argued that human law must conform to a higher moral law rooted in reason and divine order. Law as a discipline and social institution operates across several distinct levels and covers a wide range of subjects. Understanding this scope is essential before examining how law relates to political science. At the most fundamental level, law is divided into public law and private law. Public law governs the relationship between individuals and the state. It includes constitutional law, administrative law, and criminal law. Private law governs relationship between private individuals and entities. It covers contract law, property law, family law, and of course civil wrongs. Constitutional law is the branch of public law that is most directly relevant to political science, as it deals with the foundational rules and principles that define the structure of government, distribution of power amongst different branches, and the levels of authority. Establish the fundamental rights of citizens and specify the relationship between state and the individual. In India, constitutional law is based on the Constitution of India, which came into force in 26 January 1950 and is one of the world's longest written constitutions. Administrative law governs the activities of administrative agencies and regulatory bodies created by the state. It ensures the public authorities act within their legally defined area of activity or within the jurisprudence as defined by law, defined power, and follow fair procedure. International law regulates relations between sovereign states and international organizations. One of the most fundamental observations connecting political science and law is that law is created by political institutions. Law do not emerge spontaneously from nature or reason alone. They are made by specific public or political actors operating within a specific political system. Legislatures pass statutes, executives issue regulations and ordinances, courts create precedents through their judgments, constitutional assemblies draft constitution. All of these law creating institutions are political institutions, and understanding how they work requires political science. In democratic political system, legislation is the primary form of lawmaking. Legislatures, parliaments, assemblies, and Congress pass law through deliberative political processes that involves debates, committee scrutiny, voting, and executive assent. The outcome of this process reflects the distribution of political power within the legislature, the ideology of the ruling majority, the demands of interest groups, and the constraints imposed by constitutional limits. In India, Parliament is the supreme legislative body at the national level. Parliament consists of two houses, the Lok Sabha and the Rajya Sabha, whose constitutional function, power, and procedures are defined by Articles 79 to 123 of the Constitution of India. When Parliament passes a law, it is simultaneously a political act reflecting political choices and priorities, and a legal act creating enforceable rules that bind all citizens. The political context in which laws are fundamentally created fundamentally shapes the content, character, and direction of legal system. Political ideology, political conflicts, and political power all leave deep imprints on the laws that govern society. This shaping of law by politics is one of the most important themes in the interdisciplinary study of political science and law. Historical examples demonstrate this powerfully. The abolitionist movement at the United States, which was ultimately a political movement, produced the 13th Amendment Act to the Constitution in 1865, abolishing slavery. The Civil Rights Movement, again a political movement, produced the Civil Rights Act of 1964 and the Voting Rights Act of 1965, transforming the legal landscape of race relations in America. In India, the political movement led by the Indian National Congress against the British colonial rule ultimately produced the Indian Constitution of 1950, a legal document shaped by the political values, struggles, and compromises of the independent movement. Political ideology also shapes how existing laws are interpreted and applied. A government committed to social welfare will interpret labor laws, environmental regulations, and social security provisions expensively. A government committed to economic liberalization will interpret the same more narrowly and may seek to amend them to give greater scope to market forces. Law makes its first and most fundamental contribution to political science by providing the constitutional framework within which all political activity takes place. A constitution is not merely a legal document. It is the foundational political charter of a state. It defines the political system, distributes power amongst different institutions and branches of government, establishes the procedure through which political decisions are made, and sets the ultimate limit on what political actors may do. It defines the do's and don'ts of both the state government as well as the citizens. For political science students, constitutional law provides essential knowledge about the formal structure of government. Understanding how the Indian political system works requires knowing the constitutional provisions that define power of the president, prime minister, relationship between union and states, the independence of judiciary, the functioning of parliament, and the rights of the citizens. Without this constitutional knowledge, political analysis remains incomplete. The constitutional framework also determines the scope of scope of political competition. In India, for example, the constitutional division of legislative subjects between the union list and the state list and the concurrent list in the 7th schedule defines the arena within which political competition between the central government and the state takes place. Political parties compete for control of different levels of government because different levels hold different legal provisions. Rule of law perhaps is the single most important concept linking political science and law. It refers to the principles that all persons, institutions, and authorities, including the government itself, are equally subject to the law and must act within the legal bounds. Under the rule of law, no one is above law. Decisions are made according to established legal rules rather than arbitrary personal will, and those who violate the laws are held accountable through legal processes. The rule of law has both a formal dimension and a substantive dimension. In its formal dimension, it requires that laws be publicly known, consistently applied, and non-retroactive, meaning that people cannot be punished for action that were not illegal when they were performed. In its substantive dimension, are as developed by thinkers like A.V. Dicey and Lone Fuller, it requires that laws meet certain moral standards of fairness and justice, that they do not themselves violate fundamental human rights. The rule of law is a central concern of political science because it defines the relationship between political power and legal constraint. History provides many examples of government that possess enormous political power but that operated outside legal constraints, operating by the arbitrary will of rulers rather than by law. Law makes a third major contribution to political science by establishing legal limits on the exercise of political power. This contribution is closely related to the rule of law, but deserves separate examination because it speaks specifically to the mechanisms through which law prevents the abuse of governmental authority. In constitutional democracies, political power is limited by law in several ways. First, constitutional divide power between different institutions, the legislative, executive, and judiciary, so that no single branch can accumulate unlimited authority. This doctrine of the separation of powers given by Montesquieu and of course John Locke associated with the is embodied in the Indian Constitution through the distinct and balanced roles given to Parliament. In President, the President, the Council of Ministers, and the Supreme Court and High Court. Second, constitutions grant enforceable rights to citizens that political authorities cannot violate. In India, Part 3 of the Constitution, Article 12 to 35 guarantees fundamental rights including right to equality, Article 14, right to freedom of speech and expression, Article 19, and the right to life and personal liberty, Article 21. These rights can be directly enforced by citizens against the state through petitions in the Supreme Court under Article 32 or High Court under Article 226. The relationship between political science and law is not one directional. While law contributes to political science by providing constitutional frameworks, the rule of law and legal limits on power, political science contributes to law by explaining the role of the state in making, interpreting, and enforcing legal rules. This contribution begins with the recognition that law does not exist or operate independently of political power and political institutions. The state is the primary lawmaking body in modern society. Political science explains what the state is, how it is organized, how the political power within the state is distributed and contested, and how state institutions interact with each other and with civil society. This political understanding is essential for understanding how law is made, why certain laws are enacted and others are not, and why the same formal legal rules may be applied differently in different political context. Political science also explains the political forces that drive legal change, social movements, political parties, interest groups, and electoral pressure all shape, and of course civil societies all shape the legislative agenda and determine which legal reforms are pursued and which are blocked. The decriminalization of homosexuality through the Navtej Singh Johar case or judgment of 2018 exemplifies how political advocacy by rights groups gradually shifts the legal landscape of democracy like India. Political science makes a second major contribution to law by analyzing how political systems and political ideologies shape the development and character of legal systems. This contribution goes beyond explaining how specific laws are made to examining the deeper political foundations of entire legal traditions and systems. Legal systems do not develop in a political vacuum. They reflect the political values, power structures, and historical experiences of the societies in which they develop. The common law tradition, which prevails in England, India, Australia, Canada, and United States, developed from the English political experience of gradually limiting royal power through judicial precedents and parliamentary legislation. The civil law tradition, which prevails in France and Germany and most of the continental Europe, developed from a different political tradition of systematic codification of law by centralized state authority. India's legal system is a product of its specific political history. The colonial encounter with British rule introduced common law principles, English legal procedures, and codified criminal law through instruments like the Indian Penal Code of 1860 and the Code of Criminal Procedure post-independence. India retained much of this legal framework while transforming it through a new constitution reflecting the political values of democracy, justice, liberty, and equality. Political science makes these connections analytically visible. Among the key concepts linking political science and law, the Constitution holds a uniquely central place. A Constitution is both a legal document and a political document. As a legal document, it is the highest source of law in a state. All other laws must conform to it, and any law that contradicts it is invalid. As a political document, it embodies the fundamental values, political compromises, and institutional arrangements that define the political community. Constitution can be written or unwritten, rigid or flexible. Written constitutions like those of India and the United States are contained in specific documentary texts and typically require a special procedure to amend. Unwritten constitution like that of the United Kingdoms are not contained in a single document but consist of statutes, conventions, and judicial precedents that have accumulated over centuries. Rigid constitutions like India, rather I should say rigid constitutions like America, require supermajorities in the legislatures and sometimes ratifications by states to amend. Partly rigid and partly flexible constitutions like India have both the procedure, the simple procedure, the amendments that can be done by simple majority, amendments that require special majority along with ratification from the state. The drafting committee was chaired by Dr. B.R. Ambedkar, who brought to task a formidable combination of legal expertise and political vision, wherein we deliberately made our constitution partly flexible, partly rigid, not so easy to amend, not so difficult not to be amended as per the changing circumstances. Rights and duties constitute another key concept, bridging political science and law. Rights are legally or morally protected entitlements that individuals hold against others, particularly against the state. Duties are corresponding obligations, either legal or moral, that individuals and institutions owe to others. The recognition, protection and enforcement of rights is one of the most important functions of both legal systems and political systems. Political science provides the theoretical foundations of rights. Political philosophers from John Locke to Immanuel Kant to John Rawls have developed theories about which rights individuals possesses, why they possess them, and what obligations these rights generate. Locke argued that the individual possesses natural rights through life, liberty, and property that exist independently of government, and that governments are created to protect these rights. Rawls argued that rights are derived from principles of justice and rational, individuals would choose behind a veil of ignorance without knowing their position in society. Law translates these philosophical concepts into enforceable legal rules. The Indian Constitution codifies rights in Part 3, fundamental rights, and in Part 4, fundamental duties, introduced by 42nd Amendment in 1976. Fundamental rights include different kinds of right to equality, freedom, right against exploitation, freedom of religion, cultural and educational rights, right to constitutional remedies, etc. Justice is the fourth and philosophically the richest concept, like political science and linking political science and law. Justice is simultaneously a legal value, the goal that legal systems aspire to serve, and a political value, the standards a standard against which political institutions and arrangements are evaluated. Both disciplines are fundamentally concerned with justice, though they approach it from different angles. In law, justice is primarily procedural and institutional. It concerns the fair administration of legal rules, the impartiality of courts, the equal treatment of similarly situated individuals, and proportionality of punishment to offences, timely justice, etc. The phrase justice delayed is justice denied captures the legal understanding that even substantively just rules are unjust if they cannot be assessed or enforced in a timely manner. In political science, justice has a broader meaning that includes distributive justice, the fair distribution of social goods, opportunities, and burdens across society, and social justice, the elimination of systematic inequalities based on caste, class, gender, religion, and ethnicity. These concerns with distributive and social justice go beyond what courts can deliver through individual adjudication. The preamble to the Indian Constitution promises citizens social, economic, and political justice, a commitment that is simultaneously legal and political. The Indian Constitution is without, question the most important Indian example of the intersection of political science and law, and it deserves careful examination. As a case study in how legal and political thinking combine to produce a foundational political and legal document. Constitution was the product of intensive deliberation by the Constituent Assembly that completed its task in 3 years, from December 9, 1946 to November 26, 1949. Constituent Assembly consisting of 299 members drawn from the provinces and princely states of British India, led by Dr. Rajendra Prasad as president and B.R. Ambedkar chairing the drafting committee. The assembly included remarkable individuals who brought legal, political, economic, and philosophical expertise to the task of constitution making, like Jawaharlal Nehru, Vallabhbhai Patel, Aladi Krishnaswamy Iyer, K.M. Munshi, T.T. Krishnamachari, and many others. The constitution that emerged from these deliberations is a remarkable synthesis of legal technique and political vision. From a legal perspective, it is a comprehensive and detailed document that defines governmental structure with precision, assigns legal authority to specific institutions, and establishes enforceable rights. From a political perspective, it reflects carefully negotiated compromises on federalism, the relationship between religion and the state, the treatment of minorities, the protection of socially disadvantaged groups, and the balance between individual liberty and social welfare. Fundamental rights are the most direct expression of the intersection of law and political science in Indian context, as they represent one of the most significant achievement of Indian Constitution. Fundamental rights guaranteed in Part 3 of the Constitution are justiciable, that is enforceable, legally enforceable, and they spread from Article 14 to 32, covering up various rights like right to equality, prohibition of discrimination, abolition of untouchability, etc., etc. 6 freedoms guaranteed from Article 19 to 22, which is often called as Article 19 as the mini charter of liberties, etc., which covers up freedoms like freedom of speech and expression, freedom of assembly, freedom of movement, etc. These freedoms are subject to reasonable restrictions specified in the Constitution itself, representing a carefully calibrated balance between individual liberty and legitimate state interest. Article 21, the right to life and personal liberty, has been interpreted by Supreme Court with remarkable creativity and expansiveness since 1978 to include a wide range of implied rights. Judicial review is the third major Indian example of the intersection of political science and law, and is one of the most powerful mechanisms through which legal institutions exercise a check on political power in India. Judicial review is the power of the courts, primarily the Supreme Court and the High Courts, to examine whether laws passed by the Parliament and the state legislatures and actions taken by the executive conform to the provisions of the Constitution. If a law or action is found to be unconstitutional, the court can declare it void. The power of judicial review is guaranteed in Article 13, 32, 226, 131 to 136 of the Constitution. Article 13 explicitly states that any law that takes away or abridges the fundamental right shall be void to the extent of such inconsistency. Having examined the contribution of each discipline to the other and studied Indian examples, we can now compare both the disciplines to understand their key differences. While deeply interconnected, there are differences, and they have distinct methodologies, purposes, and fundamental orientation that make them separate fields of intellectual inquiry. The most fundamental difference lies in their primary approach. Political science takes a normative and empirical approach to the study of power and government. It asks what political systems are like, why they work the way they do, and what makes a political arrangement just, stable, or effective. Law takes a doctrinal and prescriptive approach. It asks what the rules are, what they mean, how they apply to specific situations, and what their legal consequences are. The second difference is that of their relationship to authority. Law derives its authority from the formal sources, constitutions, statutes, judicial processes, or precedents and treaties. A legal argument must be grounded in these authoritative sources to be valid. Political science derives its authority from empirical evidence, logical arguments, theoretical framework, and comparative analysis. It is not bound by the authority of formal legal texts. Third difference relates to their treatment of conflict. Law seeks to resolve individual disputes definitively to reach a binding judgment about a specific case. The interdisciplinary relationship between the two disciplines, while profoundly productive, has important limitation. The first limitation is the risk of reducing law to politics, viewing legal rules, judicial decisions, and constitutional provisions as nothing more than expressions of political power or political interest. This reductionist view, associated with some versions of critical legal studies, ignores the genuine normative authority of law and its capacity to constrain the political power independently of political will. Law has a logic and an integrity of its own that cannot be fully taken away or fully explained by political factors. Second limitation is the inverse risk of treating law as though it operates in a completely apolitical realm of pure logic and neutral principles. Legal formalism, the view that legal conclusions follow inevitably from the application of legal rules through neutral reasoning, ignores the political choices embedded in legal rules. The discretion available to judges and the ways in which legal interpretation reflect the social and political context of the interpreter. The third limitation is disciplinary depth. Well, three areas of contemporary relevance between the two disciplines are legal reforms, governance and accountability, and the role of judiciary demonstrates this clearly in the Indian context. Legal reforms in India represent a major contemporary intersection of politics and law. India's justice system faces well-documented challenges, a backlog of over 5 crore pending cases in courts at all levels, delays that can stretch cases over decades, and access to justice problem that disadvantage the poor and marginalized. Addressing these challenges require both legal reforms, changes to procedural codes, evidence laws, and court administration, and political will to implement and fund these reforms. CRPC, the Indian Evidence Act, and the Indian Penal Code enacted during British colonial rule were replaced in 2023 by three new statutes: the Bharatiya Nagrik Suraksha Sanhita, the Bharatiya Sakshya Adhiniyam, and the Bharatiya Nyaya Sanhita, which came into force in 2024. This was simultaneously a major legal development and a politically significant initiative. The Right to Information Act of 2005 and the Lokpal Act of 2013 also demonstrate how political demands for governance accountability translate into legal mechanism. Let us conclude. We began by defining the two disciplines separately, what is law and what is political science. While law has been defined as a system of rules created and enforced by governing authority to regulate behavior, resolve disputes, and protect rights, we traced its scope through public and private law, constitutional law, and human rights law. We explored key thinkers from Austin to Aquinas to Pound. We examined the two-way relationship between political science and law. Political institutions create law, while law constrains and shape political behavior. We discuss rights, duties, justice, and the rule of law through Indian examples. We compared discipline, noted limitations, and confirmed relevance through the 2024 legal reforms and judicial activism. The central lesson: law gives politics its form, politics gives law its direction. Thank you.